Yes, we seem to have come back a fraction. Only apologise, we didn't mean to cut you off. Your
Great. Thank you very much for rising early, my lord. I hope not to be particularly long this afternoon. I hope I can address the points fairly succinctly. What I propose to do, by way of structure, is first to address some contextual points and to look at start in the case of Islam, and then go from there to look at validity and the LOTR policy. And then, if I may, we'll just look briefly at some of the facts of the cases.
Certainly.
So, obviously, in a way, this case represents an extension of the litigation in the Islam case. If I could just take you to tab 12 in the authorities bundle. One of the points that my learned friend, in his usual excellent fashion, sought to persuade the court was that there were here two applications, whereas in Islam there was only one, and that the decision makers in this case failed to give any reasons for their non-consideration, as he saw it, of the LOTR applications. My submission to the court would be that, in fact, it's not as clear-cut as that. The two, as my lord said, shade, like the questions my lord identified, one into the other. And it's important to view the context of such applications within the immigration system as a whole. And the extract I'm going to take you to, I hope, will demonstrate that point. So, turning then to the decision of Islam at page 210 of the bundle, in the judgment of Lord Justice Peter Jackson. The first point, by way of context, is the context of the rule change to the skilled worker visa system. And we have the extract, the bottom of page 210, from the explanatory statement that was appended to the statement of changes laid before Parliament. We actually have, I don't know if it would assist my Lord's notes, if the extract itself from the notes is at page 81 of the authorities bundle, but it says what it says in the extract. And perhaps the important points are these, that at paragraph 710, it's noted that the following changes are being made to the student route in response to the government's commitment to reduce net migration. And at the second bullet point, removing the ability for international students to switch out of the student route into work routes before their studies have been completed. So obviously that's the primary policy objective of the rule change. At 712 we have some expansion when it says the switching restrictions will ensure that students who are generally not switching in country to another route until they've completed their courses. Students on courses at degree level or above will be able to apply before course completion, so long as their employment start date is not before their course completion. So it's clear what the policy intention was. And in the previous section of the explanatory note, the government noted as to the commencement of the student rule changes at paragraph 6.6, and we have this in the middle of page 211, that the changes were to come into force immediately, exceptionally, in order to prevent switching occurring prior to the, after the announcement of the rule change and prior to commencement. Perhaps that demonstrates, I would suggest to the court, an intention by the government to avoid a problem which has become manifest of the abuse of student visa systems to use it as a method by which the country can be entered and then work visas sought. So that's the first point, the contextual policy point. The second point I'd like to draw out of Islam is this. In paragraph 5, page 211, Lord Justice Peter Jackson notes that the structure of the rules provide that an application under Appendix SW must meet the validity requirements in SW1, and it must meet the requirements in paragraph SW2 and the eligibility requirements in SW3. And it's worth, I think, just having a look at those because we haven't looked in detail at those yet. And if I could invite you to keep your finger, as it were, in Islam and turn back in the bundle to the rules itself. We have at page 22 the structure of the validity requirements. And first of all, at the top of page 22, there's a requirement that the application for a skilled worker must apply online on the specified form. And then at SW 1.2, an application for entry clearance or permission to stay as a skilled worker must meet all of the following requirements. And it's worth just looking through what the requirements are. There has to be a fee, and the immigration health charge must be paid, must have provided biometrics, must have provided a passport, and must have a certificate of sponsorship. And then at 1.5a on page 23, the applicant must fulfill one of conditions A, B, or C on the date of the application. So A has completed the course, B must be studying full-time, and the certificate of sponsorship must start after the end of the course, thus complying with the policy objective, or C, which doesn't apply in relation to PhDs. And then at the top of page 24, we have the, as it were, the key provision here, SW 1.6. An application which does not meet all the voluntary requirements for a skilled worker may be rejected as invalid and not considered. And of course, we now have a Court of Appeal authority on what may means in that context, is absolutely entitled to, as we'll come to in a second. And whilst we're in the appendix itself, given my Lord mentioned it, it's worth looking at SW 17. Which is on page 52. Just so my Lord sees the structure, obviously a decision on an application as a skilled worker, if the decision maker is satisfied that all the suitability and relevant eligibility requirements for a skilled worker are met, the application will be granted. Otherwise, the application will be refused. And there's a right to apply for administrative review. That's the structure within the rules. And if one then goes back to tab 12 and to the decision in Islam, we can see that, and the court is familiar, as is clearly apparent from the exchanges with the learned friend, with the construction points about the word may that were raised in the previous hearing. The case that the learned friends sought to rely on and referred to were, of course, touched on in those cases, and in particular, we have the Mahad statements, and it's perhaps important, the next point I would like to draw out is that in paragraph 27 on page 218, which in the context of the submissions made were that as a matter of language, we must, as Lord Brown has ordained, construe the words of SW 1.6 sensibly, according to their natural and ordinary meaning, recognising their statements of the Secretary of State's administrative policy. That's, of course, the phrase from Mahad. Lord Justice Peter Jackson says that in his view, and this is the final part of the paragraph, in my reading, is that the decision maker is entitled to reject a non-compliant application without any consideration whatever of the underlying merits of the application. This is strongly supported by the words validity requirements, rejected as invalid, and not considered. Now, I draw the court's attention to that paragraph particularly because the main focus of my learned friend's challenge is a reasons challenge, effectively, when he says that each of the four decisions was flawed by want of reasoning in relation to his LOTR application. Now, in our submission, because of the elision between a request to treat an invalid application as valid, which was, of course, the issue that the applicant lost on in the Islam case, with an application under LOTR, I would submit that a similar approach is appropriate in relation to considering the reasons in an application which is deemed invalid. Because when we come to look at the four decision notices, we'll see why I say that. There's also, obviously I know the court is fully aware of the contents of paragraph 28, because that was covered in the exchange with my learned friend. But the next point I'd like to...
Sorry, I'm a little puzzled by what you've just said. Can I clarify? Are you going to be submitting that in relation to an LOTR request, the Secretary of State is absolutely entitled to reject it without consideration of its merits.
Yes, and we'll see that in a second as to why I say that in the LOTR policy document. And if I may, I'll come back to that in just a moment.
Okay, thank you.
In paragraph 31, the court is there addressing submission from counsel for the appellant that the suggestion being in that case that the decision maker had to consider whether or not there was any underlying application, irrespective of the fact that he should treat it as invalid. And the court gave 3 clear reasons why that was why that wasn't the case. And it was said that the ramifications would be wide and undesirable. And the 3 points raised there apply in the context of these 4 appeals it submitted. Firstly, a further conscious decision would be required in respect of every invalid application. Adding a decision-making stage would negate the purpose for which the filter, with its accompanying fee waiver, and that's perhaps an important point, in each of these 4 cases the fee was repaid, with its accompanying fee waiver was intended. Far from achieving fairness, the burden would work against fairness and good order in the system as a whole. And that, I hope for reasons that I'll be able to demonstrate by looking at the LOTR policy, is clearly what was trying to be achieved here in terms of the public policy of actually implementing the prohibition on abuse of the student visa switching to skilled worker visa problem that had arisen. The second point, if discretion existed, it would be impossible to exercise it without investigating an investigation of the suitability and eligibility of which the filter is plainly designed to avoid. And that would have been an issue in the present cases equally. And as Lord Justice Peter Jackson noted, anything less would be an empty and formalistic exercise. And then the rule SW 17.1, which the court has just looked at, provides that valid applications must be refused if the suitability and eligibility requirements are not met. It would be a perverse and unintended outcome if makers of invalid applications were in a better position to challenge decisions. There's then, and if I may, just taking my submissions since we're in Islam, at paragraph 34, the court considered matters in relation to the principle of whether or not there was going to be any substantive difference, which is a point that is made by the respondents in the present case, and I will return to that in due course. Finally, in paragraph 44, Lady Justice Andrews, forgive me, paragraph 42, initially, Lady Justice Andrews noted that, and this is along the same lines of the paragraph I've just taken the court to, the interpretation urged on us by counsel would require the Secretary of State to explain why a decision had been taken to reject, and that where an application does not meet the mandatory requirements of immigration rules, which would achieve nothing unless there may have been some good reason to accept it, which in turn raises the spectre of having to consider the substance of the application, as Lord Justice Peter Jackson pointed out. In other words, it would defeat the very purpose of the change to the rules. So what was being dealt with in the case of Islam was a challenge to the automaticity element that had been brought about by reason of the rule change. This case is another category of challenge to that automaticity element.
Well, before we get on to this case, I assume you would accept that there's not a word in Islam about LOTR.
Indeed not, because on the facts of that case, Mr. Islam had not made an LOTR application. The appellants advanced the case on the basis that there was a duty to consider the exercise of discretion by reason of the word may. Yeah. So it is a different scenario.
That contention, as you point out, was rejected.
Yeah. Then, if I may, I'll just go briefly to the validity policy document that Malone referred to the court to, which is behind tab 5 of your document. Perhaps I could start at page 93, which sets out the about this guidance section. and it's intended to assist decision makers in considering to decide, or describes how to decide whether an application is valid, second and third lines, and what to do if it is not. At page 18, so page 107 of the bundle, learned friend took us to one of the requirements, which is, and you'll see the structure of the document, is that there are various requirements in headings with a colon, and then, so for example, proof of identity at 104, consent for applicants under 18 at 106, and then requirement of previous leave. So there's a requirement, where there's a requirement of previous leave, this guidance provides that, as my learned friend...
My apologies, I've lost the place. Could you...
Forgive me, 107 by the upper whole.
Yes, but where on page 107?
Just under the heading requirement previous leave.
Yes, okay, thank you.
Routes which have their own rules on validity requirements set out what previous permission an applicant must have had to make an application under that route. And then indeed, as it happens, picked on the appendix skilled worker route as an example. And one will see that from the extract that there are various conditions who a person must have been granted that sort of permission. And the guidance says in the paragraph by the lower hole punch hole beginning, you may decide. You may decide on a case-by-case basis to exercise discretion when considering this validity requirement. For example, where a person has previously been granted leave outside the rules, it is likely to be appropriate to exercise discretion and treat the application as valid and allow them to make an application as a skilled worker. Of course, in this case, all of these applicants had been granted student visas, and none of them had completed their studies. Can I turn then to the leave outside the immigration rules policy document we have behind tab 6 at page 124. On page 126, under the heading about this guidance, the court will see that this guidance, and this of course is merely guidance, it doesn't have the same status as the immigration rules. If the court were to find there was a conflict, there is little doubt as to which is the more persuasive and significant.
Well, I don't have any difficulty at all with the proposition that the immigration rules have a superior status because they're subject to the negative resolution procedure and therefore have, to that extent, parliamentary approval, whereas this document doesn't. But nevertheless, would you dispute that this is a statement of the Secretary of State's policy?
Well, it's a statement. Strictly speaking, this is a guidance document. As you see from the front page.
But it's guidance to the Secretary of State's staff.
Yes.
And therefore it must be surely telling the Secretary of State's staff what her policy is.
There are documents expressly which say they're statements of policy. For example, the Arab scheme has a policy document. This is specifically expressed as a guidance document. There is I would submit, a kind of hierarchy. But clearly, even as guidance...
I don't have any difficulty with the idea of a hierarchy. On the contrary, that seems to me to make sense. But what I'm questioning is not the proposition that there's a hierarchy. I think there plainly is. But even if this is lower down in the hierarchy, why is it not still a statement of policy?
I don't disagree with that statement, but it's not a capital P policy.
Right,
if I can put it like that.
Thank you.
But isn't the position, whether it's guidance or policy, that the Secretary of State should follow it unless she articulates a good reason for departing from it?
Yes, and I hope to show you in the text why that has been done.
All right.
In these cases.
But you would accept that as a general proposition?
Yes.
Yeah.
I think I'm probably bound by authority to accept that proposition.
Yeah, I thought you might.
So, paragraph, sorry, forgive me, page 126 in the top paragraph, the introduction provides that the guidance tells you about when it may be appropriate to exercise discretion to grant leave outside immigration rules on the basis of compelling or compassionate grounds. And you'll see in the final line of that paragraph, this guidance applies to decision makers considering entry clearance, leave to remain, and indefinite leave to remain applications. So it's, I suppose, in the context of my learned friend's clients' applications, they are applications for leave to remain, but it's a little perhaps unclear as to how that is put. But what is clear is that this guidance doesn't relate to, as you see from the second paragraph, those who are claiming for LOTR as a result of potential violations of the European Convention on Article 3 medical discretionary leave, or where there is an existing published concession. So this guidance relates to those, to a limited category of applicants. And if we turn then to page 128, we can see that in the paragraph I think my learned friend has already taken the court to, the second last paragraph from the bottom of the page, LOTR may be granted where the decision maker decides that the specific circumstances of the case includes exceptional circumstances. And perhaps I think this part wasn't focused on. The circumstances will mean that refusal would result in an unjustifiably harsh consequences for the applicant, but which do not render refusal a breach of ECHR Article 8 and Article 3 of the Refugee Convention or other obligations. So there is perhaps an important test there that is being enunciated as to where LOTR would be appropriate. And that's fleshed out over the page, on page 129. The learned friend took the court to what's under the heading Reasons to Grant, but perhaps it's important for the court to notice what is said under the heading Important Principles. The first important principle is that the grant of LOTR should be rare, and the discretion should be used sparingly where there are factors to warrant a grant of leave, despite the requirements of the immigration rules not having been met. Factors raised in their application must mean it would not be proportionate to expect the person to remain outside of the UK or to leave the UK. So that is the test that's enunciated there. And then what's particularly important in the light of my contextual submissions that I made a moment ago, the immigration rules have been written with clear objectives, and applicants are expected to make an application for leave to enter or remain on an appropriate route under the relevant immigration rules and to meet the requirements of the category under which they're applying, including paying any fees due. And this is perhaps the most important sentence. Considerations of whether to grant LOTR should not undermine the objectives of the rules or create a parallel regime for those who do not meet them. And that final phrase perhaps encapsulates what it is the appellants are attempting to achieve by these appeals. It's also of note that in the final paragraph under that heading, the period of LOTR is discussed. And it's said that the period of LOTR granted should be of a duration that is suitable to accommodate or overcome the compassionate, compelling grounds raised. None of the applicants express any indication of how long they say they should be granted LOTR. They simply seek LOTR in an open-ended way. But that's contrary to what is an important principle in the grant of these applications. Because as it says, most successful applicants would require...
Can you just tell me on that? If the Secretary of State were to decide that in a particular case the most that could be justified on the basis of LOTR was 1 year's leave to remain, would that justify a decision not granted at all?
But not of itself, because clearly one of the factors in considering whether or not...
Why does it matter that what's been applied for is open-ended?
Well, because it indicates...
it remains open to the Secretary of State to say, well, I'm not going to give open-ended LOTR, that's ridiculous, but I'll consider granting it for a year or 2 years.
But that's the... Yes, I agree with my lord, that's the point. The point I'm trying to make, forgive me, I'm making it rather clumsily perhaps, is that... the length of the duration of the LOTR should relate to the underlying compassionate reason. Here, it is said in each case that the compassionate reason is the agent made off with the fees which were going to pay my student fees, but I wish to work in the UK for reasons that aren't set out. And I don't wish, and I haven't said any reason why, but Mr. Periyasamy says that there might or might not be somebody in India who may threaten him, but in all the other cases, there's no indication of a length of time as to why they should be permitted to work, nor indeed why a working visa in the United Kingdom is the answer to the reported theft of the fees that should have been paid to the university. And so, just to come back to my Lord's point, the decision maker on a proper LOTR application is considering compassionate, compelling grounds, which will, of itself, and you see this in the examples that are set out, there is a reason where one can foresee how long that grant should be for, and that is missing in these cases, and that's why I draw the court's attention to that paragraph. Does that answer my Lord's question?
I think that's good enough for now. Let's carry on.
Thank you. In particular, may I draw out one part in the middle of that paragraph? Indefinite leave to enter or remain can be granted outside the rules where the grounds are so exceptional they're warranted, but such cases are likely to be extremely rare. That is an important principle in the granting of LOTR. Similarly, in the following section, my learned friend drew out the test in the first line, exceptional circumstances which would mean that refusal of entry clearance would result in unjustifiably harsh consequences. None of the four applicants, as we'll see, identify what those unjustifiably harsh consequences for them may be, potentially aside from Mr. Periyasamy, of them not being granted a skilled worker visa or allowed to remain on that basis. But perhaps it's also of note, as we'll see in a second, that there's an inconsistency between the two applications. Because if I just take you to page 133 in the authorities bundle, page 10 of the guidance policy, the decision maker is required to consider conditions for the grant of LOTR. And in the final paragraph it says this: conditions for limited leave should be no recourse to public funds, no work and no study. Any deviation from this should be rare, and only where there is sufficient evidence to show why such conditions should not be applied. So there is an inconsistency in the applications made by the solicitors for the various appellants to say, on the one hand, grant me a skilled worker visa, but on the other, grant me LOTR. Because the consequence of LOTR, applying the guidance, would be
well, that might constitute a reason for rejection of LOTR, but where do we find that reason articulated in any of the decisions?
Well, as we'll see in a second, the guidance itself, I mean, obviously our argument is that this is a parasitic attack on the creation of skilled, the tightening up of the skilled worker.
You mean parasitic or collateral?
Might probably mean both, actually.
Okay.
But
And all.
it's clear that what is happening here is that a set of applicants have realised that on the face of it they don't now meet the new requirements under section 1.6, so they seek to make an LOTR application. What I sought to bring out by our careful analysis of Islam was, and our careful analysis of the important principles of LOTR, was that this is in effect an attempt to create a parallel regime for those who don't meet the system. And this is an abuse of the LOTR system. And as a result, it's somewhat preemptory, but not entirely, I mean, it's not completely disregarded, it is touched on in the decision documents, is as a result of the correct approach to be taken in an attempt to abuse the system. And for those reasons, it wasn't, and we'll come when we come to the decision documents, I hope to show you why that is. It wasn't necessary for all this to be set out in detail, because one would fall into the same problem that was identified by Lord Justice Peter Jackson in paragraph 31. That effectively, you're going into the benefit of the filter is being removed, in that you're having to go into the facts underlying the case, and what would be the purpose of the filter in those circumstances.
All right, but can you point to anything in this policy document that gives the Secretary of State an absolute entitlement to reject a request for LOTR without considering
it? Yes, but if one just looks at the way that the document is constructed, perhaps if I can just take you back to page 129. So obviously the test is set out, and unjustifiably harsh consequences for the applicant or family, but which do not render a refusal a breach of the ECHR. And at the top of the next page, as my own friend pointed out, LOTR will not be granted where it's considered reasonable to expect the applicant to leave the UK despite such factors.
It's my fault.
And then there's a passage.
I've lost the place. Can you give
top
me
of
the
page 130
Yep.
of the authorities bundle.
Yep.
Then we have documentary evidence. And this, I would submit, is a fundamental part of an LOTR claim. You have to have documentary evidence.
Well,
and this ties in
I'll
with
come back to what documentary evidence means, but at the moment I'm struggling to understand how the passage you've just relied on supports the proposition that there's an absolute entitlement to reject an LOTR request without considering it, because the sentence LOTR will not be granted where it is considered reasonable to expect the applicant to leave UK despite such factors seems to carry with it a requirement to consider the request on its merits.
So my submission won't be that we have not considered the LOTR applications. In each case, the LOTR application was touched on in the decision documents. Now, because the applications were invalid, there wasn't a formal refusal document. But it amounts, in essence, to the same thing. The LOTR applications were not approved.
Well, sorry, you now seem to be making a different submission, and that's not to say that it's wrong. I just want to clear up where we stood on the first submission, because the submission you were making is that the Secretary of State has an absolute entitlement to reject an LOTR request without considering its merits. Now, if you're abandoning that submission, that's fine, and we can move on to the submission that you've just articulated, which is a different one. But if you maintain the submission that there's an absolute entitlement to reject an LOTR request without considering it, I'm still puzzled as to what the basis for that is.
Well, forgive me, my Lord, I understood my Lord's question to be, can the LOTR decision be considered and rejected without a consideration of a statement of the reasons why you've reached that decision? And I'm hopefully going to show you that that is not a requirement.
Well, that again is a different question. That's about the extent of the duty to give reasons. So I would still like to be clear as to whether you are maintaining the submission you did articulate that there is an absolute entitlement to reject an LOTR request without considering it. Because if you maintain that submission, I would like to know the basis for it. If you abandon it, then I don't need to worry.
Well, I suppose the phrase is, the word there, considering it, is the seat of perhaps my misunderstanding of my Lord's question. By considering it, what I'm submitting is that obviously if an LOTR application is made to the Secretary of State, then the Secretary of State should consider it.
So you
but that
accept
consideration...
I'm very sorry to keep interrupting. It's just I need to break it down into stages because otherwise I get lost. So you are accepting that if an LOTR request is made, then the Secretary of State must consider it.
Well, if I may expand on the word consider. So obviously that's a variable concept, because in the light of our submission about seeking to set up a parallel regime, that consideration is obviously then, there's a difference between a consideration of an LOTR application, which is a freestanding LOTR application made on an LOTR form, and we'll come to that in just a second, which is considered by the Secretary of State and reasons are given and is refused or allowed accordingly. But in the circumstances such as this, where effectively it's being used to try and circumvent a provision in the immigration rules, then they can be considered, albeit in a light touch way. That's is my argument.
Okay, so let me see if I've understood the submission you've just made. You say if it's a freestanding LOTR request, then the Secretary of State must consider it. If the LOTR request is made in the alternative to an application under SW16, you say what? The Secretary of State doesn't need to consider it?
No, I'm saying that it's always, as is the way with these things, context specific.
So it still needs to be considered, but the extent of the consideration somehow differs. Yes?
It does. And it does because of the important principle that considerations of whether to grant LOTR should not undermine the objectives of the rules or create a parallel regime for those who do not meet them. That justifies a variable geometry approach to the consideration of questions of LOTR. I appreciate, my lord, that has a lack of concision about it, but I hope that my lord grasps the submission that I'm seeking to make. That there are...
I'm just struggling to understand how this works, because let's take a freestanding LOTR request. In those circumstances, it seems pretty clear that what is needed is to ask, well, are there compassionate and compelling grounds put forward? And if there are, well, might that justify LOTR of some duration, and if so, on what conditions? No, what's put forward is not compassionate and compelling grounds, therefore no LOTR. So that's the type of consideration that is entailed according to this policy document. How does some different form of consideration work if it's the application for LOTR is made in the alternative to SW 1.6?
It's not the fact that it's made in the alternative. Forgive me, I set that hair running in a way that it has been unhelpful to the court. What I mean is that where an LOTR application is made in a way which contravenes one of the important principles, one can expect that application to be treated more summarily than one that does not.
In which case one would expect the decision letter to say, well, this is that category of case. We've regarded it as an attempt to circumvent the rules and create a parallel regime, and for that reason it fails.
Well, can I come back to the decision letters in a second?
Yeah.
But I entirely see the point my lord makes. I would submit that in terms of the application of the policy in the real world, that is the treatment was appropriate is the answer that I'm going to give to the court when I get there, if I may.
But can I, while we're on this, some of the letters anyway talk about a threshold.
Yes.
For consideration or for grant. Is it your submission that the policy document, or the guidance rather, that we're looking at contains threshold requirements for consideration?
Yes, I think the threshold is set out in the first paragraph under the heading Reasons to Grant LOTR. compelling compassionate factors are, broadly speaking, exceptional circumstances which mean that refusal of entry clearance or leave to remain would result in unjustifiably harsh consequences, but which do not breach the convention. That's the threshold.
So is it
So the
a
threshold
bit
of
like
the
a
merits
sort of
seems-
strikeout? You say that you haven't identified facts that, if established and if considered, might give rise to the grant of LOTR, or is it something else? Because otherwise, if it's something more complicated than that, one gets into your Peter Jackson LJ 31 problem, doesn't one?
Exactly, my lord. Yes, that's exactly right, and it defeats the whole point of having the filter. Which
So is this analysis that the guidance tells the decision maker acting on behalf of the Secretary of State that they should look at the application for LOTR and ask themselves, are the circumstances alleged capable of giving rise to a case worthy of consideration, or something like that, or what?
I'm not sure that the decision-making process is as elaborate as that. I think the word threshold.
Well, so is your point that the threshold question is, are there exceptional circumstances which would mean that a refusal, blah, 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 would result in unjustifiably harsh consequences?
Yes.
That's your submission. That's the threshold.
Yes.
Right. In which case, the threshold and the merits seem to merge into one.
Well, can I address those submissions when we're actually looking at the relevant decision letters?
Yeah.
Because I think it's probably clearer. I agree. There is. I would remind the court, and I will remind the court, obviously, of the very sage words of Lord Brown in Porter about the necessity for reasons and the statement of reasons. It's clear, I think, defining a fine difference between a threshold and a merit is, I think, an overly rigid application in this type of decision, an invalidity decision of this nature made by a caseworker.
Well, there's a simpler answer, namely there is no threshold.
Well, the threshold is the same. I mean, there is a threshold for the grant of LOTR as set out in the paragraph on page 100.
So that seems to be an acceptance that in the real world, the threshold and the merits are the one and the same.
Yes, the reason I added that caveat was this, that when we look at the decision document, I don't want to, as it were, it to be said, well, Lord Murray, you said that there's no separate threshold in the merits. When we look at the wording of those particular documents, I will seek to persuade the court that...
I don't want to be difficult about this, but this is an important aspect of the case, as it seems to me at the moment, for this reason, that as you've forcefully pointed out, when we look at the skilled worker appendix, for very understandable policy reasons, a very clear decision was made to the effect that if your application is invalid, it will be thrown out and not considered. And this court in Islam has held it necessarily follows that there is no duty upon the decision maker to consider exercising any discretion. And therefore it also follows no reasons need to be given at all. However, what at the moment it seems to me we search for in vain when we look at this policy document is anything that says if your application is invalid, it will be thrown out without consideration of its merits.
So there is no such passage in the LOTR policy document, and the reason for that is that LOTR is, as it says,
It's exceptional.
so it has no particular criteria upon which it can be said to be invalid per se.
Yeah.
So that's why it's important to look at the guidance to the caseworkers as to what...
But why can one not therefore cut to the chase and say, when applications are made for LOTR, it's exceptional, and therefore it necessarily follows that such applications can be rejected without requiring elaborate reasons. But does it follow that they can be rejected without giving any reasons?
Well, I would submit that very short form reasons were given. And I admit that they are very short form. But that, in the submission of the Secretary of State, is sufficient in this context. Because that's consistent with preserving the purpose of the filter. And back to Lord Justice Peter Jackson's paragraph 31 point.
Okay, thank you.
Can I just return to the documentary evidence point? Because there are a number of points in the decision letters where my learned friend said, well, he says he's got no evidence, but there's evidence in the form of a witness statement prepared by the applicant and his solicitors. The guidance itself refers to the need to provide documentary evidence on page 130. And, for example, it says that where an applicant seeks to remain to overcome a personal tragedy, they must provide evidence of the reasons that they must remain in the UK.
Okay, can you help me on that? When we read the word documentary evidence, what in your submission does that mean? Does that exclude a witness statement?
As one will see in a second, from the second paragraph, it's anticipated that it's something more than just a witness statement. So a witness statement could probably form part of it.
Well, just help me on that, because it goes on to say, where an applicant seeks to remain to overcome a personal tragedy, they must provide evidence of the reasons they must remain in the UK and for how long. Well, taking that sentence on its own, I appreciate that's not a proper way to read the document, but just for convenience, that would seem to be something you could readily explain in a witness statement.
I agree with my lord, but it's really the contents of the second paragraph that I draw this, because that's perhaps a more useful example.
Right. Satisfactory medical evidence from a medical practitioner. Now that might take the form of a witness statement from the medical practitioner.
Or a note or a letter from the medical. That would be a documentary evidence. I think that's the kind of thing that the draft of the guidance is envisaging.
So I think you're accepting that in context, a witness statement could be documentary evidence.
Yes, that's absolutely right. But one would expect from the wording that the guidance is seeking more than that.
Do you submit it seeking corroborative evidence?
Well, yes. I mean, ultimately, that's what. For example, in the medical circumstances described in the second paragraph, that would amount to corroboration, wouldn't it? A note from the GP corroborating what the applicant has said in their witness statement or their application form. And it would also set out the reason for the period of leave on compassionate grounds. So it would be kind of corroboration at that point too, as one can see. Such evidence must include details of the relevant medical circumstances of why it requires a period of leave on compelling compassionate grounds.
Okay.
And what we would say, I mean, in one case, some further documentation was provided with the witness statement. But
WhatsApp messages.
The WhatsApp messages. But in the rest of the cases, it serves as were self-serving evidence from...
Well, one of the cases, corroborative witness statements were provided.
So there's a witness statement from the father in relation to going to the police in India.
Yeah.
Yes.
And a statement from the lawyer.
And with the lawyer's identity card, I think.
Well, there's more than that. There was a statement
There
from
was
the
a
lawyer.
statement from the lawyer.
So that is evidence which goes beyond just a witness statement. And that clearly one can see the sorts of documents that LOTR caseworkers are directed to consider from that paragraph. Turning then to paragraph, page 132, the paragraph by the Lower Hull Council, applying in the UK for LOTR. My learned friend took the court to the paragraph that begins, applicants in the UK must apply on the application form for the route which most closely matches their circumstances and pay the relevant fees and charges. Any compelling compassionate factors which they wish to be considered, including any documentary evidence, must be raised within the application on their chosen route. If the requirements for leave on their chosen route are not met, I leave it to the court to determine in those two cases where the covering letter wasn't expressly referred to. I don't particularly put any great weight on that point, but what I do put weight on is the fact that my learned friend said that the skilled worker visa applications closely match their circumstances. He never said how or why. Why should the fact that a person who came here to study, and in many cases they've been here for a number of years without studying, suddenly, just before the expiry of their leave, seek to put in applications for skilled worker visas? Why does it closely match their circumstances, the fact they're the subject of a theft?
Well, can I be clear? What do you say they should have done? Because what we can see from the guidance document is it says that if an applicant wishes to be considered solely outside the immigration rules, then they apply using FLR HRO.
Yeah.
And we know that, in fact, 2 of these applicants did just that, but then they varied them. So is your submission that that's what they should have done? They should have stuck with FLR HRO? Or is it your submission that actually there was some other application form which they should have used and they didn't use?
Yes, I make that point, and I make it in connection. So
which is it?
The first format. So I make that point that they could have used the some other form other than SW, for example, that for expressly for FLHRO.
And how does that work if your application is, first I want waiver under SW 1.6, and in the alternative I want LOTR? How does that work if you apply on FLR HRO?
Well, then we come back to the point about conditions, don't we? Because the condition on the grant of LOTR should be that there's no work.
Well, I understand that point, but that seems to me a distinct point from what you're submitting at the moment, which is your present submission, I thought, correct me if I'm wrong, was that the applicants had used the wrong form. And my inquiry, therefore, is, well, which form do you say they should have used?
Well, it's not as simple as they used the wrong form. My submission is more, if I may say, more sophisticated than that, in that it is one of the questions that the court will ask itself. Why did they want to be in the UK? They wanted to be in the UK because they wished to have to work ostensibly with a visa. They say in the submissions made both below and today that that application closely matched their circumstances, all of which goes to demonstrate the weakness of the LOTR application and the fact that this amounts to a collateral attack on the prohibitions and the validity requirements of the skilled worker system.
Right. So as I understand it, it's my fault. I had misunderstood the point you were making. You're not saying they used the wrong form. Your point is the fact that they were applying in the alternative, and that in reality there is no close match. You say that supports your proposition that this is a collateral attack.
And there's been no submissions as to why it does closely match their circumstances.
Okay.
Then just to the page 136, the refusal wordings, the one that was linked from the paragraph that Malone and Friend pointed to. I just simply wanted to make the point that whilst Malone and Friend took you to exceptional circumstances raised implicitly or explicitly in the wording, the suggested wording, but I make the point that it is just that, it is suggested wording. And at the top of the page, one can see this section sets out suggested wordings for decision makers to use in a refusal letter. The wordings are examples. They do not constitute an exhaustive list of possible refusal paragraphs. And again, I would submit that in order to reach a decision which concludes in paragraphs like those, it would require a study of the underlying documents, which would have the effect of defeating the filter. So before we go to the facts, I just want to take you then to, just for the purposes of these cases, obviously, as at page 14 of the bundle, we have section 16 of the Tribunal Courts and Enforcement Act. And the court is very familiar with the provisions of section 16.3e. And this concerns the test for permission. And this is a challenge to permission. So if one considering the question mentioned in subsection 3c, it appears to the tribunal to be highly likely that the outcome for the applicant would not have been substantially different. The tribunal must refuse to grant permission. And I would submit that there's nothing in the evidence, as we will about to look at, that means that there would have been any, had there been further reasons given in relation to the LOTR applications, the outcome would have been the same. So, turning then to the first case, Mr. Kalidasan. If I may, I'll just outline some of the key dates. It's important in that context to note that Mr. Kalidasan did not seek to vary his leave until shortly before the expiry of his student leave. And that was almost 2 years after his arrival, despite him having not studied in that period. It's said that he made an application on the 16th of January 2024 and thereafter sought to vary it on the 4th of May. But the application made in January 2024 was never validated as Mr. Kalidasan failed to enrol his biometrics. By the time that reminder letters were issued about the biometrics, he had already made his skilled worker application. In relation to the exercise of discretion, Mr. Kalidasan requested the waiver of the requirement to have completed studies, but in fact he hadn't even commenced his studies. He'd taken no prompt action to leave the UK or to regularise his position for 2 years, during which his stated intention of studying in the UK had been thwarted. And if we just turn to the decision documents in the bundle, at page 132, he asks for, on his form, permission to stay as a skilled worker and the reason he gives for that is simply that he was unable to study. And in the form itself, he just says, please refer to the covering letter. We have that at page 139. And we turn then to page 139. Sorry, the covering letter is at page 122, I believe. If one looks at page 123, all he says is at paragraph 10. The appellant continued to chase the agency and only repaid the money in November 2022, but the university would not accept payment as the deadline had passed. EA did not want to jeopardise his future in the UK and therefore sought a sponsor. But there's no explanation about the period of delay, nor is it suggested that there is any exceptional circumstance which meets the threshold or merits test that we've looked at. There is extensive, at page 128, extensive discussion about the case law on discretion outside the rules, but very little explanation. Paragraph 31 at page 130. It just said the A repeats that he's been the victim of bad luck and his dreams of studying his MSc in the UK have been broken by theft within the agencies. He trusted to organise his overseas studies. If it had not been for the action of the agency, he'd been able to complete his studies. It's not said why, or why should that lead to him remaining here to work, and for how long. So faced with that, the decision maker was obliged to consider the application, and that is at page 119. And obviously the approach of the decision maker is that principally the application that's made is an application for a skilled worker visa. As we've looked at by the lower hole punch hole, you've attempted to make an application for permission to stay in the United Kingdom, where application has been rejected as invalid and will not be considered for the reasons set out below. And at this stage, he's only made one application on two bases. First, on any reading of the letter, he says, firstly, consider me for a variation, a waiver of section 1.6, or alternatively, LOTR. But it was appropriate and fair for the decision maker to regard it as one application, since it was all reflected in one application notice. And so he says that in the second last paragraph, as you've not completed your studies and withdrawing from your course due to unpaid fees, the Secretary is not satisfied that you meet the requirements. Your application is invalid. And then says, we note the further representations, and that includes the LOTR application. We've taken these representations into consideration, and it has been decided that discretion or leave outside immigration rules is not appropriate in this instance. Now, I appreciate that it is a cursory treatment of the application, but the submission is that this was sufficient in order to preserve the purpose of the filter that was introduced for these reasons. And as a result, the decision of the 6th of August 2024 dealt with both applications.
So that seems, forgive me if I'm caricaturing your submission, I'm not intending to. But that sounds very close to a submission that giving no reasons at all is sufficient. because of the need to preserve the filter.
Well, it doesn't give absolutely no reasons. It doesn't just say your application is rejected.
Well, in relation to LOTR, what reasons do you say are given?
That it's not appropriate.
Right. And you say that's reasons, is it?
Well, as I say, it's an expression of how the decision maker viewed the application. It's not what one would conventionally consider to be reasons. But the reason for that, as I say, is that it is intended to preserve the effect of the filter, as my lord notes. Because if it were otherwise, if the decision maker then had to get into the reeds of the facts set out, it would.
But is not the reality of your submission that you're saying actually in this context there is no requirement to give reasons, because this is a collateral attack and that's the end of it. Therefore, you don't have to give any reasons. I mean, that I can understand. But as soon as you accept that some reasons are required, then I'm struggling, because a statement is not appropriate seems to me to be unreasoned. Now, if that's what the decision maker is entitled to do, then fine. But I struggle with...
I have to concede, my lord, the reasons are not fulsomely expressed.
They're not elaborate.
But I mean, it's certainly, there is a certain appeal to the formulation that my lord has said, that the requirement to give reasons is vitiated in circumstances where its intent is to defeat a filter. But I realise that my learned friend in his reply will, I'm sure, tell the court that well, there's lots of case law that says you have to give reasons for any decision that it doesn't expressly provide you with other options, as in Islam. So it may be that I would like to ride both horses. I wonder whether I can.
Yes, of course.
Of
course, you can make the submission in the alternative.
There might be a basis for doing that, perhaps, because on this twin track approach, the applicant is saying, I want to work. I don't qualify because I did have a student visa and I don't meet the requirements there. Please waive that. That's one thing, and you would say, well, this is all just an attempt to get round the policy expressed clearly in the changes to the rules. Leave to remain outside the rules on compassionate grounds, entirely separate. Disregard the intent to work for the moment. I just want to stay here for exceptional reasons. And I think all the authorities say you've got to give reasons for that. Maybe that's not an attempt to get round the skilled worker route on its face if it's considered entirely separately. Then you've got some difficulty saying no reasons.
I agree, it is fact sensitive, isn't it?
Yes.
So it depends on the case that's before the court, and I would submit that in each of these four cases, fortunately, I don't have to deal with that rather knotty hypothetical.
Okay, thank you.
So I think that deals with Mr. Kalidasan. Then, forgive me, I might very briefly look at the Upper Tribunal's judgment in relation to him.
Do we really need to get into that? I mean, Mr. Malik is the appellant, so he was under some duty to take us to the reasoning, but at the end of the day, it's a question for us now, isn't it? I mean, is there an arguable case for JRR or not?
It is. I would simply say this, that I think there is an element that this court, of course, will give appropriate deference. These are, the Upper Tribunal judges see these cases day in, day out.
Oh, for sure. They're an expert tribunal, to be sure. But...
So with that caveat, just that, the judges they see a lot of these cases.
Sure.
And
well, if there's something that you think will help us, by all means, let's look at it.
Yes, so this is Judge Smith refusing permission at an oral permission hearing on page 66. So, really, this is the point. So, Upper Tribunal Judge Smith, routinely, obviously, very familiar with this jurisdiction, heard full argument from counsel, and considered the questions in relation to paragraph 1.6. And as I think my Lord Justice Warby noted, this decision actually predates the judgment in Islam. And so it was open to the judge to find that there was an arguable case, potentially, on the construction of the word may. There are some rather, some grounds that weren't pursued with particular vigour. And in particular, the judge noted the mandatory validity requirements. And paragraph 6, as my learned friend has already taken the court to, she held that the respondent was only required to consider whether there were circumstances sufficient to justify waiving the mandatory requirements, and she was not required to do more than that. And she found in the final 3 lines that she was arguably not required to do more than recognise that she had a discretion, take into account the representations, and then decide whether they were sufficient to depart from the mandatory validity requirements. And so it seems, therefore, that the Upper Tribunal judge rolled together the applications in a way that I suggest is the correct way, and my learned friend seeks to disambiguate them. So that was my only point on the Upper Tribunal judge's decision. So then, case 2, Kaliyamoorthy. The application, as we've looked at, is at page 309. Yes, this Kaliyamoorthy, yes. So, I just want, if I may, just touch on the facts, just to outline the facts, the relevant facts from the respondent's perspective in relation to Mr. Kaliyamoorthy. So his student leave was initially granted from the 6th of December to the 29th of 2022 to the 29th of May 2024, but it was curtailed on the 17th of September 2023, which resulted in a new end date of the 16th of November 2023. He made an application for further leave to remain on the 5th of January. However, he failed to enrol his biometrics, with the result that that application was rejected on the 26th of June 2024. His student leave was curtailed as the University of Aberdeen withdrew sponsorship. And Melena Frensk had an argument at paragraph 38 sets out why he says that happened. There's no explanation provided in the evidence as to why he didn't attempt to regularise his stay promptly after it became apparent that he could not study as he intended, and in fact remained for approximately 10 months in the UK for no apparent purpose. Once his leave was curtailed, he was unable to study, and he then made his late application for LOTR, which was then not followed up because he never validated it by enrolling his biometrics. So it was only on the 14th of May 2024 that he made this application that is in front of you now as a skilled worker and sought the exercise of the discretion to waive. But on the basis that he had completed his studies, but in fact he'd never engaged with his studies. He also asked that a period of overstaying from November 2023 should be overlooked. So that's the factual background behind Mr. Kaliyamoorthy. And again, the reasons he gives for the LOTR application are found in the cover letter, which begins at page 301. Again, he says he was the subject of fraud. And that begins at the LUTR application part of it begins at paragraph 33, and again sets out the case law. And at paragraph 37, he simply says, the A asserts his dreams of studying the UK were destroyed by fraud and manipulation by an agency in India. He's done his best to rebuild his life and has been identified as a suitable worker by an A-rated sponsor, but there's no suggestion there as to why he should remain in the UK to address the exceptional circumstances of the application. And indeed, perhaps it's unsurprising, therefore, in the conclusion of all these letters, the principal request is for leave to remain under skilled worker visa, but the LOTR is in the alternative, very much the second alternative in all of the applications. So then turning to the decision in that case, we had the minded to refuse letter, so he was given an opportunity to expand upon those reasons. And you've seen, my learned friend took you to the response, which didn't add very much to the reasons given. I can take you to that, page 84 of the supplementary bundle. And then we have the rejection decision at page 257 of the main bundle. Again, each of these decisions is slightly different, but this is page 256 of the main bundle. You've applied for a skilled worker visa. You must meet the validity requirements stated in immigration rules, appendix skilled worker. So it's clear there the decision that's been made, and that's very Islam compliant. And then the history is set out in the decision letter. Perhaps in a way, in some of the other cases, it's not. So, for example, the curtailment is set out at the bottom of page 256, and the place to which the visa cancellation notice was sent is set out. And that was in September of 2023, and then it just observes that in May 24 you submit an application for permission to stay as a skilled worker.
As you rightly observed, all of these letters are slightly different. What do you say to the point about this letter, that in fact it's completely oblivious to the request for LOTR? Because if you look above the second hole punch on 257, it refers to the letter of the 2nd of October, and says discretion has been requested regarding the validity requirements. There's no reference anywhere to LOTR, and the statement by the second hole punch is simply concluded discretion will not be granted. So on the face of the letter, the request for LOTR seems to have been completely ignored.
So I have to agree with my lord that does appear to be the case on the face of the document. However, I would say that for the caseworker determining this, and it would have been clear we've looked at the letters, but it would have been clear that the exercise of discretion was effectively being made on all the same points as the LOTR application. And the decision maker regarded the word discretion, I would conjecture, as incorporating the LOTR application, because they are founded on identical facts.
So this goes one step beyond your submission on the previous letter, where your first submission, as we clarified in the course of debate, was that it was sufficient to give no reasons for rejecting LOTR. So in this case, you say you don't even have to give no reasons, you don't even have to address it at all, because it's sufficient to say, well, I've exercised discretion against you, without even saying that you've considered the relevant request.
Clearly, in circumstances, I mean, it is not ideal. I have to obviously concede that to the court. But we live in the real world, and the decision maker is there considering the applications that are actually before him on the facts. The fact he hasn't used the words LOTR application in the decision letter doesn't undermine the force of his conclusions, because if one looks at the paragraph between the upper hole punch hole and the lower hole punch hole, the content of both the LOTR application and the discretion to waive application is set out, that he was forced by an agency in India to discontinue his course of study, and that it stated his mother had reported this to the police in India. So this was all evidence in support of both applications. But I have to concede, my lord, of course, that in a perfect world he would have expressly mentioned the LOTR application. But
It's vulnerable to the suggestion that the mind was not turned to that aspect of the application because it's not referred to.
vulnerable to that suggestion, but I think it's defeated by the fact that the evidence underlying that application was considered. That would be my submission. I realise that I'm in slightly difficult territory on that point, but clearly the matter was subsequently litigated, and the application was certainly well known to the respondent, and the respondent in the judicial review claim maintained the decision and didn't terminate, as it says in the summary grounds, which are found at page 215.
Going back to the decision, could it be said that the ref says that there's the introduction, please find and close a decision relating to your client's application for permission to stay, blah, 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 and the appellant is addressed, you've attempted to make an application for permission to stay in the United Kingdom, your application has been rejected as invalid, will not be considered for the reasons set out below. Does the reference to the application for permission to stay include both aspects of that application for permission, i.e. The application under the skilled worker provisions and the application for leave outside the rules?
Yes, I mean that's what we must say. It's the only way.
Despite the fact that the third paragraph says you've applied for a skilled worker visa.
Well, that is
which
true.
of course is true, but
Yeah.
but there was more to it.
I have to agree that it's far from perfect, but
So there's
but
inter
it
alia is missing from.
unfortunately, as I say, there is definitely a real-world element, I'm afraid, to analysing this.
Yes.
But
Okay.
the case against you, obviously, is that South Buck says that there shouldn't be any ambiguity about whether there's an error of law, and there might be here.
Well, forgive me, the phrase in South Bucks, which with classic Lord Brand concision, is significant doubt. And I don't believe there is significant doubt as to how the decision maker reached his decision, because he's set out what the evidence he's considered, albeit in a pithy summary. In fact, the reasoning on the facts is better than.
Well, you say that, but the reason for giving on discretion is lack of evidence. Well, that's questioned.
But he does set out what the evidence. It's clear that there isn't sufficient evidence to sustain. I mean, he gives an account of himself in his witness statement, Mr. Kaliyamoorthy. But
Well, let me be more precise. Sorry, I should have been more precise in putting to you what Mr. Malik actually submitted. My understanding was that he focused on the complete phrase, lack of evidence to substantiate your claims. So, what Mr. Malik submitted was, well, how does one know from this whether the account is accepted that said, well, that doesn't justify LOTR, or whether the account is rejected?
as we know from our review of the rules, the appendix skilled worker application there was an entitlement to administrative review. In the event the applicant chose to commence judicial review proceedings. Whilst I understand my own friend's contention, the reasoning is, in the Secretary of State's submission, still sufficiently clear. And doesn't breach the cardinal principle, which I outlined at the beginning of permitting the rule change to be the subject of a parallel process. But then I don't want to rehearse those submissions again. Can I perhaps invite the tribunal to look at how the Upper Tribunal dealt with this point, which is at page 188. Again, experienced Upper Tribunal judge hearing from counsel at a renewal hearing. This decision was obviously the subject of extensive submissions, the question that the tribunal considered itself to be answering is set out at paragraphs 19 and 20. And the tribunal at 20 say that it may be that the respondent could have given more detail about why substantiation would have been reasonably available, or about other reasons that she was disinclined to believe in, but I consider the duty to give reasons too varies with context. In the context of an invalidity decision, which is meant to filter out applications that do not merit consideration, where the respondent had no legal duty even to consider exercising discretion, the duty to give reasons is limited accordingly. And obviously this is post-Islam, so Islam is referred to expressly. And that was the line that was taken before the tribunal. And what's of note is that the LOTR line advanced by my learned friend now is clearly not a significant feature in the Upper Tribunal's decision making. And if the appellant...
But I'm right in thinking it was a ground of challenge. I mean, it may not have... I mean, I would agree with you that reading the decision, it doesn't look like it was emphasised in oral argument. But am I right in thinking that it was nevertheless a pleaded ground of challenge?
Can I just check? I've read all the sets of pleadings the grounds are at.
So grounds 28, the grounds are set out at pages 289 and following.
Very good.
So there's breach of Article 8. So there are two grounds to do with Article 8. Equality of law, necessary in a democratic society. Ground 2, failure to exercise discretion, paragraph S1. 6, ground 3, required to give 14 days notice. So there doesn't seem to be a ground about LOTR in this application for judicial review.
So I think that's that. And hence the point which arises that careful consideration given by the tribunal as to whether to grant permission on the basis of the grounds advanced.
As pleaded, yeah. Well, the Upper Tribunal can't be criticised for not considering a ground that wasn't pleaded.
Shall I move to Mr. Periyasamy? Does the tribunal have any more questions about Mr. Kaliyamoorthy? May I just start by outlining some facts in relation to Mr. Periyasamy. He held student leave between the 2nd of June 2022 until the 19th of May 2025, which was curtailed on the 2nd of January 2024, providing a new end date of the 2nd of March 2024. He made an asylum claim on the 19th of February 2024, and then made this application for a skilled worker visa on the 13th of June 2024. Now, in relation to the asylum claim, On the 22nd of February, he attended a screening interview. And on the 29th of September, he was invited to attend a substantive asylum interview on the 8th of October. And on the 8th of October, he failed to attend his asylum interview.
So the asylum claim was dismissed on those grounds, wasn't
Well, on the 9th of October, he was written to give an opportunity as to why he failed to attend. And on the 22nd of October, his asylum claim was then withdrawn for non-compliance. He made submissions on the 23rd of October to reinstate his asylum claim, which was then reinstated on the 9th of October 2025. So, obviously...
So that is ongoing.
Yes. He maintains that he's at risk in India due to his association with a politician, and it therefore would appear that he has more than one concurrent application to stay in the United Kingdom.
But is there anything in the law that prevents that?
No.
And so what's the relevance of the asylum claim for our purposes? I mean,
Well,
that will have to be considered on its own merits.
of course, but it goes, does it not, to the court's consideration of whether there was any reasonable alternative outcome to this application.
Why so? Why can we not simply assume that the asylum claim will fail? I mean, of course, it will have to be considered on its own merits, and if it succeeds, then that will be an answer. But why do we not simply assume, for present purposes, that it fails?
So what we have is, in these two applications, applications for skilled worker status issued before his latest asylum claim. In the event that the skilled worker application is granted, in the event that the skilled worker application, so in the hypothetical world where this claim succeeds and the decision maker has to reconsider his skilled worker visa application, the point is it's now known that he's making an asylum application, and there are points in the asylum application, which I'm about to come to, which conflict with his current account, and it's therefore highly likely that his application will reach the same conclusion.
Can I just ask about that procedurally? That wasn't one of the grounds on which the Upper Tribunal refused permission for judicial review, and there's no respondent's notice. So I was just wondering where we are in relation to that point.
Well, obviously it's a statutory requirement that the tribunal, considering the question of permission, must consider whether or not it would be highly likely to achieve the same outcome. So my submission is that it's simply a statute.
We have to look at
draw
it anyway.
attention to.
Yeah.
So I don't need to make an alternative submission on the point. But the asylum claim is perhaps material in this way. There was clearly a failure ever to engage with his proposed course of studies. Similarly, there was a failure to make an earlier attempt to regularise his presence in the UK. He utilised approximately 17 months of student leave until his curtailment, apparently with no purpose to be in the country. The asylum claim, it also conflicts with the evidence in the present case, and in the asylum screening interview, he made a number of statements which contradict, which are difficult for his application in relation to the skilled worker visa, and they're set out at paragraph 36 of my skeleton. It's therefore highly unlikely that, given the conflict, that he's likely to succeed in his application for a skilled worker visa. So that's those are the submissions in relation, introductory submissions in relation to Mr. Periyasamy. court have the point that the covering letter, which we have at page 457, was not expressly referred to in the application notice. He said, just look at the covering letter. Again, we're familiar with the letters used by the solicitors for the applicants, and the relevant paragraphs appear at page 457. The law is set out, and the material paragraph is at paragraph 29, and he says that the applicant avers he should be given the chance to assist the UK economy in a skilled worker occupation, which has been identified by the Home Office as requiring migrant labour. The EA has also been the victim of fraud and an unlawful decision to cancel his leave. It's not explained how that would meet the threshold for LOTR. It's not something that, nor is it explained why he's applied using the skilled worker route in the context of all the submissions that I've made in relation to the other applicants. We know that, in fact, what he's done subsequently is reapply for asylum. And then we have the decision itself. I suppose I better take the tribunal to 429. It begins at 427. Again, it refers to an application for permission to stay in the United Kingdom. And this one says, therefore, you must meet the validity requirements stated in the immigration rules to a skilled worker. Your rejection is treated as invalid and will not be considered for the reasons set out below. And
so I think this is a second letter which doesn't address LOTR.
So yes, that's right. At 429, though, forgive me, but if we just look at the reasons that are given, the application, the point my lady made, obviously, the application has been made for permission to stay in the United Kingdom, and the decision maker is considered to be invalid, and then sets out the facts upon which the application is made, and in particular setting out the contact with the Home Office, which you have at the bottom of page 428, and at the top of 429, the decision maker notes, forgive me, the bottom of 428, top of 429, we have carefully reviewed all the information provided, including the arguments and evidence presented in the solicitor's letter. So that must incorporate the standard form paragraphs about outside the rules, the applicant's witness statement and other supporting communications.
How can one have that confidence when it goes on to say, after thorough consideration, decisions be made in accordance with the immigration rules, including SW16? That rather strongly suggests that the one thing that hasn't been considered is outside the rules.
I mean, I appreciate that the focus of the decision maker is clearly the SW16 application, and I struggle in the same way that I did in the other case, but that does not mean that the decision maker would not have considered the application. And as we've seen in the covering letter itself, it's not as if, aside from citing the law in relation to LATR applications, the one material paragraph doesn't even mention exceptional circumstances or anything approaching a reason as to why he should be considered under LATR. So, in fairness to the decision maker, what else was he supposed to do? He focused on the meat of the application, which was this was a skilled worker visa application, and the criticism of form that he should have mentioned the LATR application is, probably fair.
This may be a convenient juncture to address a submission of Mr. Malik's that is not at the forefront of his submissions at all, but nevertheless is relied on, as he made clear. which is, even if we focus upon SW 1.6, so ignore his maiden thrust, which is LOTR, even so far as SW 1.6 is concerned, Mr. Malik accepts, as he has to, in the light of Islam, that the Secretary of State is absolutely entitled simply to say validity requirements not satisfied and throw out the application without further explanation or justification. However, he argues that although the Secretary of State has that absolute entitlement, if the Secretary of State does not simply say, well, this is invalid, that's the end of it, goodbye, but instead purports to exercise a discretion to decide whether or not to waive the invalidity, and decides not to waive the invalidity, then at that point the duty to give reasons kicks in. And again, they may not need to be very elaborate, but they must be sufficient.
This is in light of the paragraph from Lady Justice Andrews.
In particular, yes, and Lord Justice Peter Jackson specifically said he agreed with that. So all members of the court subscribe to that.
Indeed, I think it's most clearly expressed by Lady Justice Andrews. But I would agree that is one of the outcomes of Islam. That clearly the submission in Islam was that a statement should be given irrespective of the fact there was no application. And there was no application in Islam's case. So that was the lens through which that question was being visited. In a case where it is raised, it's clear from the judgments that there should be, albeit in short form, a consideration of whether the waiver should be permitted.
Well, no, sorry. Maybe I haven't made myself clear. That's not the point that's being argued. It's accepted, and it has to be accepted, the Secretary is under absolutely no duty even to consider it. The Secretary of State is entitled to say, consistently with the policy, your application is invalid, that's the end of it. However, the submission is where the Secretary of State or the decision maker chooses not to do that, but instead goes to the next stage and considers whether to waive, not something that the decision maker is obliged to do, but nevertheless does do, and then decides not to waive, then reasons must be given. That's the argument.
Yes, my lord. I'm just looking again at the wording of paragraph 44 on page 221 of the authorities bundle.
Mm-hmm.
So she doesn't say in terms that it requires consideration. It's an extrapolation, I think, of an friend, but not an unreasonable one. That in the event that the decision maker is tempted to consider whether to waive, then, to use Lady Justice Andrews' words, they need to demonstrate in the decision that such consideration has been given. Whether that amounts to a cursory statement of reasons rather than just saying, I have considered it and decided not to do it, is perhaps moot, but it would seem sensible.
Well, as I say, one needs to be very clear what the argument is. Lady Justice Andrews makes very clear here that there's no duty on the decision maker to do it, and therefore no duty to say why it's not being done. But once you advance to the stage of saying, okay, well, this application is invalid, but nevertheless, I'm going to consider waiving the invalidity, and then you decide not to waive the invalidity, the argument is, at that point, the duty to give reasons kicks in.
Can I, it's a hypothetical that I'm tempted not to answer.
It's not a hypothetical. On Mr. Baddock's case, that's the second string to his bow. It's not his primary case, but it's the second string to his bow.
In these 4 cases, the requests to treat the applications as valid were appropriately handled, and there was no requirement, there was no express consideration of which triggers any requirement to provide reasons. I can see that in certain cases, as Lady Justice Andrews envisaged, there might be more of a case, but these are not those cases.
I mean, I must say, looking at the reasons why these applicants failed to qualify, why their applications were invalid, was that they didn't come anywhere near fulfilling any of the conditions A, B, and C. They hadn't completed a study, they hadn't even begun it, as you pointed out. They weren't studying at a full-time course of study which came anywhere near qualifying. So they weren't near-miss cases. And one could see that if the application for waiver had been, well, very close to just fall outside this qualification for this reason, then they might have got there. So a decision letter which gave some reasons might have said, well, you're just nowhere near qualifying. You're nowhere near having a valid application. Isn't that a completely different thing from leave outside the rules? And so as you said earlier, reasoning has to be contextual. And in the context of this decision, you might say the reasons can be extremely brief.
Certainly, I would submit that the reasons that given are brief and necessarily should be brief, tying back to my earlier point, the point that Lady Justice Andrews made 2 paragraphs ahead of that paragraph 44, because otherwise it would defeat the point of the filter. But the question my Lord asks is a very interesting one. In the context of near-miss cases, say, for example, in a hypothetical where an applicant has a start date for a job that's a week before their graduation, there may be an argument for a specific waiver application that one of the conditions is met in relation to that. And in those circumstances, if that was refused, a short explanation, for example, we don't believe that you'll graduate or something, might be appropriate. But in the context of these cases where there's a very wide miss, it's appropriate that the decision maker can take the view that simply finding that the application is invalid without exploring the reasons for not waiving is an appropriate course, I believe, consistent with.
Yes, but that's not quite an answer to the submission, because that would justify a decision letter that says your application is invalid and is therefore rejected. But the argument is, and I asked the question for the last time, if the decision maker chooses not to do that, but to entertain a request for waiver, to consider the request for waiver, and to reject the request for waiver, then at that point, so it is argued, some reasons must be given. Sufficient reasons.
Well, brief reasons. Yeah.
And your answer is that on the facts of these cases, they miss by a country mile, and so saying what was said, for example, on page 49 is enough. Is that the submission?
Yes, that's my submission, but I do want to answer my Lord's question, because I can see that it's the court are interested in it. And it is an interesting and difficult question. And my answer is that you would, in those cases, although I'm reluctant to, obviously it's not this case, expect a very brief statement. Because I think that would be consistent with what Lady Justice Andrews said. Does that answer my Lord's question? I'm sorry that I've...
Well, I think you're adopting the point suggested by my lady, namely, and indeed my lord, that you're saying the reasons given are adequate in the context.
Yes, I am saying that. I'm certainly saying that. Forgive me, I was trying to address the hypothetical too.
Well, I don't think it's a hypothetical. that's where I'm less certain.
Well, in that case, my lord has the answer. So with that, we can leave the decision letter of the 8th of December 2024 and turn, I think, to the UT's decision.
Now this is another, I've looked at the grounds here and the way that this proceeded. This appears to be another case where the grounds of challenge have evolved, as so often they do. Could you just take us through the scope of the challenge?
And I'm just about to do that. Thank you. The initial claim.
Rounds of pages.
Forgive me.
Starts at 569.
I think we're on.
We're still in case 3.
Oh, sorry, we're still on.
Periyasamy, yes.
I'm so sorry. That's my
I'm
fault.
sorry, lady.
Jumping ahead of myself.
So we have.
Ground starts at 418, I think. Is that right?
Yes. It is. Sorry, 396 was the sealed notice. Yeah.
And I was just looking at the renewal grounds, having cut out this bit.
Yes, well, the renewal grounds, I was thinking they made it more useful.
Yeah.
That begins at page 369.
There was only one ground in the original grounds, and it was just bettering of discretion.
Yes.
Yes.
I mean, on one view, the renewal grounds went beyond the original ground, and then the grounds that were argued orally went beyond the renewal grounds.
Yes, as you say.
And was there any application to amend?
Not that I've seen, but I'm conscious that I may not be as familiar with the proceedings of the tribunal as learned friends instructing solicitors. So.
Sorry, can you just remind me where the renewal grounds are, please?
So page 377.
377. Right, the ground now is it's irrational not to consider the exercise of discretion on S 1.6.
Yes, and so then we have the oral submission summarised in the judge's judgment. So this is page 365. Again, this was argued by Milena Friend and counsel for the respondent. And the original grounds are discussed at paragraph 3, and paragraph 4 noted the council submitted that respondent had failed to engage with the evidence. And at paragraph 7, the renewal grounds are points in relation to the asylum claim, because of course the asylum screening interview was before the tribunal.
Just pausing there, paragraph 5, the counsel for GLD pointed out was that this nor inadequate reasoning had ever been pleaded.
Yes. Yes, thank you, Matthew.
The new ground not arguable, not included in the original grounds. That's paragraph 8, little Roman 1.
Yes, the judge will have to forage, dig and mine. Very well known.
Here, here.
But anyway, what I'm not seeing here is any anything about the leave outside the rules.
Okay. No, so it wasn't before the.
Well, it doesn't seem to be. I'm certainly not claiming to be an expert on what was or wasn't argued. But just looking at the documents, I wasn't able to detect something about leave outside the rules. There was a challenge to the decision not to exercise discretion, and then that begs the question of whether that phraseology encompasses leave outside the rules.
Forgive me, before we leave Mr. Periyasamy's case, I should just take the tribunal to the, I alluded to it, but the asylum screening interview from 2023 is in the bundle. It begins at page 432. The part I referred to is at page 437. Where he says that he, in the middle of the box 3.1, I did not come to the UK for any other reason.
Well, hold on a minute. You've got to read that in context. Because he goes on to say, I used the services of an agent. I paid him £14,000, included tuition fees. When I arrived at the university, I discovered he didn't pay the tuition, and so on. So,
Yes.
he's clearly acknowledging there, indeed more than acknowledging, he's saying he came to study.
That's right, I was about to take you through that. But he goes on to say that I did not intend to return back to my country.
I just want to get out of India, but I thought I will study when I come here. But I could not study because my agent wouldn't pay the fees. Just want to get out of India and be safe.
So I merely draw the court's attention to this because it may be relevant to your factual section of your judgment.
Okay.
What was the date of the interview?
So the date of the interview, the date is on page 450.
450.
So I think it's the 22nd of February 2024. That's when it's signed. So the date at the bottom is the 9th of October 2023.
I think that's just the date that this form was generated.
But I think that's
That's
right.
the
So
version of the
the
form.
handwritten date at the end is February
Yeah,
24. There is a chronology which my own friend provided, which will probably give us the answer, which is at page 363.
All right, anything else on this case before we go on to the next one?
No. Thank you. I'm afraid the chronology doesn't cover it. Yes, then the final case, and thank you, my lord, and thank you for nudging the submissions on, Mr. Muthusamy. Just by way of introduction as to the fact of his appeal, he held student leave between the 14th of December 2022 and the 26th of August 2024. On the 4th of September 2023, his leave was curtailed to expire on the 5th of September 2023, when he was placed on immigration bail. The fee waiver for his further leave to remain application was made on the 21st of September. He applied for skilled worker leave on the 29th of September, and his fee waiver application was declined on the 14th of November. Given that he was on bail, he would be ineligible for a grant of permission as a skilled worker with reference to SW 2.2, and that was the cow point that we looked at earlier, but I don't propose to spend any time on that. His application is at the back of the core bundle, 624. Again, request for a skilled worker visa, this job being retail manager, set out on page 650. And he refers, he doesn't refer, I think, to his covering letter in his application notice.
No.
As far as I can see, I'm just checking that. My learned friend will correct me if I'm wrong about that. And the covering letter itself is at page 639, similar to the others we've seen. And at page 642, it adds the text about discretion. Interesting, it's headed discretion outside the rules. Perhaps that filters back to the point that Federal Justice Warby asked me about whether discretion incorporated the LOTR application. Is even the same language that's being used by the solicitors. And the paragraph, the relevant paragraph reads, in this case, A is a young person with precisely the skills required under the Home Office's occupational skills policy. In the public interest, that A is given the opportunity to contribute to the UK economy as envisaged in Appendix Skilled Worker, that there's no separate submissions in relation to LOTR. There were obviously a minded to reject letter and a response. My learned friend has taken the court too. And then the decision letter itself is at page 633. Again, the decision maker described it as an attempt to make an application for permission to stay. The application has been rejected because the application has been rejected as invalid. Top of page 634 will not be considered for the reasons set out below. And then obviously the extract is set out. And at the bottom of the page, the last grant of permission.
Is this the right decision letter?
Oh, I'm so sorry.
Because we were referred earlier to a later one. I think this one was withdrawn.
Yes.
Wasn't there a later one?
Yes, and it's in the supplementary bundle. I'm so sorry. I think it might be.
Page 581.
Yes, so yes, the minded to reject notices in the supplementary bundle.
Do we need that? If there's something relevant, by all means,
No, we don't. So 581, thank you, is the substituted decision. For the reasons that Melanie pointed out, there were various exchanges and drawn and remade. The text of this letter, again, sets out the test, and the reasons were provided, and the dates that I've already gone through, and effectively the rejection was on the basis he hadn't completed his studies at Sheffield Hallam University. And at the top of page 583, the decision maker expressly refers to the fact that an application was made that the Home Office should exercise discretion in your favour, because you'd found prospective employment in an area of work described as being skilled. They say that's not a material consideration. And after all, this is responding to what's actually in the cover letter, rather than just the simple abstract.
No, that's not the cover letter. That's the further submissions, isn't it? I mean, it may be repeating the same thing.
Yes, I think the 639 is the cover letter, I think. But there is, I agree, my lord, that it doesn't make a material difference. 643.
Well, the cover letter is dated the 8th of October 2023.
Yes.
This is responding to something stated in a letter of the 11th of November 2024. Now, I suspect it's just a reiteration, but it's not the identical letter.
11th of November 2024 is page 150 of the supplemental bundle. I think what happened here is he started out saying, I'm a great skilled worker, that's why you should have me. The minded to refuse letter came out and he said, well, by the way, I was defrauded, and all of those things were eventually taken into account in the letter that we were looking at.
That's exactly right.
Yeah.
Okay, so I think it might be helpful then to have a quick look at the 11th of November letter.
So that's page 150 of the supplementary bundle. So with this, so the 11th of November letter is in response to the minded to reject notice of the 29th of October.
Yeah.
And the application itself is dated 29th of September. And the cover letter, insofar as it is one, is dated 8th of October. Which is odd. There it is.
Well, they're different years. I think the original application was September 2023.
Yes. And the letter on 639 is the 8th of October 2023.
Yeah. And then the minded to refuse letter comes on the 29th of October 2024.
Yes. And then that response comes 11th of November. Yes. So that then obviously led to the.
I mean, the interest of the 11th of November letter is that it does distinguish between the two bases that Mr. Malik puts his case on, because the basis A in the letter is discretion inherent in SW 1.6, and that's on the footing of if, which the decision maker is not required to do, the consideration is given to waiver and the decision made not, then there's reasons. And then B is LOTR. But I think it's fair to say that in relation to LOTR, although the argument is presented, that you can't simply kick that out on a threshold, there's nothing more in terms of the substance of it.
So all you have additionally in this letter, obviously it's rather better laid out than the initial letter, but it doesn't contain any further submissions directed at the test UAPR.
No. I mean, there is, of course, the additional evidence that's referred to on page 153.
Yes.
But that's as far as it goes.
Which I think then just takes us back to the decision notice briefly, page 581. This is where my Lord Justice Warby picked up the word threshold, particularly in the first document.
Well, looking at this letter again, I mean, this again differs, but it might be said to be better from your perspective in that it seems to address both arguments and gives some degree of reasons in relation to both arguments. Although, query, I think Mr. Malik submitted that the reasons given weren't enough, particularly in relation to leave outside the rules, he was critical of the language used, which he submitted was nevertheless redolent of a threshold being applied.
I think we've traversed the ground about threshold effectively. My understanding is it's an expression of the test in the guidance, which we looked at previously, and
exceptional circumstances resulting in unjustifiably harsh consequences, or however.
Quite so, lady, yes. Yeah. That don't amount to an ECHR breach, yeah. Yes. And so, as my Lord observes, this is a more detailed letter than the others, and it is a sufficient level of detail, I would submit, to meet the Porter requirements of Lord Brown. And furthermore, it, as you say, does expressly engage with the wording of LOTR that's used, but of course it's been an iterative process, and this is perhaps after the time of some of the other decisions. If we look at the judicial review that resulted, we have a decision from Judge Rimington.
Should we just have a quick look at, just see what the grounds were?
Yes. I was just about to...
So the grounds start at 579, I think. Procedural unfairness.
The grounds, I think it's 569.
Oh, I'm looking at the wrong thing.
But of course, as my Lord has already observed, there's been some...
It's the same document.
It's the same document. I've just gone straight to the actual grounds for judicial review, which start on page 579, I think.
Yes. So ground 1 is at paragraph 30, begins at paragraph 30.
Yeah.
So it's just procedural unfairness and inadequate reasons. Forgive me.
So, ground 2 is inadequate reasons. It's a bit unclear as to which argument is being addressed, but maybe both. But certainly, the ground that's being relied on is inadequate reason.
Yes. Turning then to... So Judge Owens refused on the papers at page 532. It was renewed, and we have the renewal grounds at page 5 129. Melody might look at paragraph 3.
So the Upper Tribunal seems to be focusing on the discretion to treat an invalid application as valid rather than...
Thank you, my lady. Are you referring to the decision of Judge Rimington?
Yes.
So the point about inadequate reasoning is repeated at paragraph 6.
Exactly.
Yeah.
And then addressed directly by the judge.
And Mr. Lenanton, I'm not quite sure how one pronounces that name anyway. He made the same point again, that the grounds are being expanded.
Yes.
But the judge dealt with them anyway, I think.
Yes. He concluded, forgive me, she concluded that the judge concluded that the reasons were not arguably inadequate. Paragraph 8.
Well, I think it's more paragraph 13, isn't it?
And 13, yes. Under paragraph 14, she refers expressly to the additional threshold of exceptionality.
Oh, here we are, yeah.
Well, that's a bit difficult, isn't it? Because I mean, query the extent to which the point was argued, although given what was said in 12, which is quoting a bit of the decision that's about LOTR, 13 and 14 are all looking at the rules.
Yes. Yes, I agree, my lord. That is a confusing aspect. Especially wraps it up in paragraph 16, where she says the decision was not arguably irrational. There's no indication that the material was not taken into account.
Yeah, but that's a different argument.
Yeah.
To lack of reasons.
She does say that she, well, yes, well, my lord will read it just as well as I can.
Yeah. All right.
I'm going to turn my back. Yes, I think we're already. Yeah. Okay. Nothing. Thank you very much. This is any.
Well, the question that remains outstanding is the point that Mr. Malik raised, that if, and I emphasise if we're mandated to allow one or more of the appeals, what we should do about it. should we simply remit to the Upper Tribunal in order to have a substantive JR, or should we take the extra step of deciding the JR ourselves? He invited us to take the extra step, but obviously that requires, that depends on whether your client would be disadvantaged in any way.
Yes, I was very grateful for the way, very fair way my learned friend put the suggestion, but I would submit that it wouldn't be appropriate for the court to take the judicial review decision for itself, simply because the proceedings are at such a stage where it might be appropriate for the Secretary of State to provide, for example, evidence as to extent of people claiming theft of student fees, which may assist, or indeed...
Why would that assist? I mean, because this is a reasons challenge.
Well, it depends on the basis that the tribunal, the court will remit it to the tribunal, doesn't it?
Yes, but the challenges that are being pursued are all reasons challenges.
The other significant aspect, I submit that there could be a world in which we may want to submit evidence, but the other avenue is that it may be that the matters can be compromised in any event, and it would save court and tribunal time.
All right, but your submission is we should remit to the Upper Tribunal.
Yes.
All right. Thank you very much.
But obviously, all of that is subject to the conclusions you might reach on whether there's any realistic prospect of a different conclusion being reached.
To be sure, yeah.
Thank you.
Lords, Milady, my learned friend at the outset of his submissions made a contextual policy point. Although it doesn't really matter in this case, but I think I ought to deal with the point about abuse that my learned friend made. And he suggested that suspected or perceived abuse of the student route was the reason why the policy was changed. That, with respect, is just not correct. You have behind tab 2 of the authorities bundle, page 73, the explanatory memorandum that resulted in the relevant change. Page 73, immediately after the rules. And if you go to page 81, you'll see that the aim wasn't to tackle abuse. There is no evidence of any abuse. The aim, which is entirely legitimate, is to reduce net migration. In my submission, it wouldn't be appropriate for the court to assume or proceed on the basis that there is some kind of widespread abuse by international students. That is the first point. The second point is that if you look at paragraph 7.2, this is when switching was excluded by way of the amendments. The switching restrictions will ensure that students are generally...
Sorry. Oh, I see. Yes, thank you. Yeah.
That students are not generally switching in country. So generally is the word I respectfully invite you to bear in mind. The policy wasn't that students will never be able to switch in country, and there would be no case where the Secretary of State would depart from the immigration rules or exercise discretion. The word generally means that the policy was that would be the sort of general policy. My learned friend then made submissions on the leave outside the rules policy, which you have behind tab 6. My learned friend says, you will recall that the test is unjustifiably harsh consequences. See page 128. He says that, see page 129, that the decision maker would decide whether it is proportionate to expect a person to leave the country. And he says that an exercise of discretion outside the rules should not undermine objective of the rules. Well, these are not, with respect to the tests, but even if they are, the Secretary of State hasn't applied these tests in any of the decisions on the challenge. So the point that Mullane and Friend makes, if it is correct, proves too much for the Secretary of State. What Mullane and Friend invites you to do with respect is to rewrite the policy, for the Secretary of State. Mullane and Friend invites you to introduce a threshold question in this policy. Well, if the Secretary of State wants to have a threshold, then it is for her to amend the policy to introduce that threshold. She has introduced a threshold in the immigration rules in relation to skilled worker applications. She hasn't done so in relation to this policy, and it's not, in my submission, the court's function to rewrite the policy for the Secretary of State. The second point that I make with respect is that a threshold of the sort that you see in the immigration rules cannot possibly be introduced in a policy of this sort. The argument with respect that Mullane and Friend makes is a circular argument, that you don't meet the requirements of the rules that are there for a reason, and therefore I'm not going to consider exercising discretion outside the rules. Well, you only need exercise of discretion outside the rules if you don't qualify under the rules. So introducing a threshold reflective of the rules would not be permissible. Now, there have been over the years many challenges to the legality of the immigration rules on the basis that they are unlawful fetter of discretion. The courts have repeatedly rejected those sort of arguments based on this policy, based on the fact that there is always a residual discretion to depart from the immigration rules. And if the Secretary of State is going to have inflexible mandatory immigration rules, inflexible mandatory policy with threshold, that would then raise a serious question as to whether that amounts to an unlawful fetter of discretion. For good reason, the Secretary of State hasn't introduced a threshold question within this policy. I'm not seeking to establish any parallel regime at all. It's not part of my case that Secretary of State should consider exercising discretion in every single case involving a skilled migrant, but only where the two conditions in Bihari are met, where an application is made outside the immigration rules or where the facts are striking. Mullane and Friend, with respect, also invites you to rewrite the policy when he says that there is a requirement for applicants to provide corroborative evidence. This isn't what the policy requires. Surely witness statement is evidence. And if the Secretary of State wants to have a policy that says that all applicants must provide corroborative evidence, she must amend the policy instead of asking the court to do that job. But I do also say that a policy which says that there is a legal requirement for corroboration would potentially be an unlawful policy. There is a settled line of authority in this court that there is no legal requirement for a witness to provide corroborative evidence. Failure to provide evidence, corroborative evidence that is readily available, is relevant. A decision maker can consider it in deciding whether to accept or reject the account of a witness, but it's not a legal requirement. It cannot be a legal requirement. Next, Muller and Friends says, well, why is it that I say that that the applications closely match the skilled worker route? I mean, the answer is obvious, and all you have to do, in my submission with respect, is to look at the first page of tab 2. First page of tab 4 to see the answer. So tab 4 are the immigration rules, appendix skilled worker, and you'll see what the route entails. The rules say that the skilled worker route is for employers to recruit people to work in the UK. A skilled worker must have a job offer in an eligible skilled occupation from a Home Office approved sponsor. So this is the broader summary of the route. These are individuals who are skilled workers. They have a job offer. The job offer is in an eligible skilled occupation. It is from a Home Office approved sponsor, and their employers seek to recruit them. All sort of substantive requirements of the rules are met. Muller and Friends suggested at one point that wrong application forms were used, but I think ultimately he abandoned that submission. If that isn't the case, then I would simply point out that
he wasn't able to identify any alternative form that should have been used.
Precisely. Yeah, exactly. There's one perhaps further point, which is that there are provisions in the rules that allow the Secretary of State to reject an application if the wrong form is used. So if the Secretary of State's case was that this wasn't the appropriate form, then he could have rejected it. Next, Muller and Friend refers you to Section 31(2)(a) of the Senior Courts Act 1981. In my submission, that point isn't open to Muller and Friend to make. The Upper Tribunal refused these applications on the basis that the claims were not arguable. There is no respondent's notice. If Muller and Friends seeks to uphold the decisions made below on a different basis or an additional ground, then she is required to file. The Secretary of State is required to file a respondent's notice. So this is a point that I do make. But I also submit that this surely isn't a case where it can be said that it's highly likely that the outcome for the applicants would not be substantially different. There is authority on Section 31(2)(a). The court is familiar with it. The court's task, of course, is entirely supervisory. The court should not drift into the sort of forbidden territory and start assessing the merits of the application, which Muller and Friend invites you to do.
Can I just be clear, because this is not something I'm deeply familiar with. So I've come across the jurisprudence on Section 31(2)(a). Is it established that the test under Section 16(3)(e) is the same?
Yes.
Right. Okay.
The authority, I think the last word on the subject is the judgment of this court in Bradbury. I can provide a copy if you wish after the hearing. But it's all well settled.
Usually, there's evidence on this point.
Precisely. So you don't know how the Secretary of State goes about the decision making. I mean, of course, it isn't appropriate. Muller and Friend effectively invites you with respect to essentially sit as caseworkers, look at the evidence and decide whether there isn't or is something exceptional. I mean, I took you to the evidence, not in depth, but simply highlighted relevant points. You simply don't have any evidence from the Secretary of State as to how the caseworkers exercise discretion, what is enough, what isn't enough. There is no witness statement, a point that is made in various authorities from the Secretary of State.
Well, how would evidence about how caseworkers exercise their discretion be in any way relevant anything this court does.
No. So what usually happens, Milady, and of course Milady knows this from experience, that if a defendant seeks to invoke Section 31 to a defense,
Yeah.
the decision maker would file a witness statement saying that, well, I have considered all this evidence, and although the reasons given in the decision are not detailed, but I'm satisfied for X, Y, and Z reasons that this isn't a case where it would be appropriate to grant leave. So the court will have some evidence from the Secretary of State as to how she goes about making decisions, and would go about making decision in this case if there is a remittal. But the court, this is the point that is made repeatedly, shouldn't drift into sort of forbidden territory and start assessing merits. If you are satisfied that there is a public law error, then the right thing to do in my submission is to, if the case reaches that stage, to quash the decision, let the Secretary of State make a new and lawful decision. Well, this is the sort of broad point that I wanted to make in relation to the factual points that Miller and Friend has made. But you have my submissions as to why the decisions are defective, the reasons are inadequate. Just one final matter to deal with, which concerns the question of pleadings. So I take no credit for drafting grounds of judicial review. But may I simply just deal very briefly with two particular points. First, in relation to Mr. Kaliyamoorthy, the second appellant. So the grounds that you looked at when Miller and Friends was making his submissions are not the grounds of judicial review for the purpose of this claim. There was an earlier judicial review claim that was challenging a cancellation decision. And Miller and Friend took you to page 283 of the bundle, where you looked at the grounds. Well, those are the grounds in the earlier judicial review proceedings. So the grounds that appear at page 283, you can simply ignore those grounds completely. If you look at the date on those grounds, you'll see that this is page 298.
Well, that's fine, but can you show us the correct ones?
Yes. So the correct grounds are page 244. So these are the grounds that are relevant for these proceedings. And if you look at paragraph 3 of those grounds, the point is that the Secretary of State acted unreasonably in failing to lawfully exercise a statutory discretion. Statutory discretion being discussion of section 3(1), failed to take into account relevant evidence, ignored representations made. If you look at the body of the grounds, paragraph 32, that is about exercise of discretion. The author says that, well, the point about discretion was made in the solicitor's letter. There was then a decision, then the point is made at paragraph 34, the point that I made in my submissions, that witness statement is evidence. And it isn't a case where there is lack of evidence. At paragraph 37, that the respondent failed to consider representations and exercise discretion. And those were the reasons in the first set of proceedings. Then may I take you to page 418. This concerns the third appellant. The grounds of judicial review in the case of third appellant, page 418. if you go to page 424 and see paragraph 19, you'll see a complaint that you'll see that the point being made that a request was made to exercise discretion outside the immigration rules as well. And then see paragraph 21, the point is that, I mean, I wouldn't have made the point in that way, but the point is that the respondent had forgotten to insert reasons for refusal. I mean, it's another way of saying that, well, there were no reasons because there is no engagement with the evidence. Paragraph 22, no engagement with representations as to the discretion. Paragraph 25, last sentence, residual discretion, discussion under the immigration rules and or her residual discretion. Not in an ideal way. The grounds do make the sort of broad point that I have made, which is that the Secretary of State's approach to her discretion is flawed. Her reasons are defective and inadequate. I think in the last case, it's accepted that is a properly pleaded reasons challenge. Just in terms of going forward, so if I may ask you to look at page 17 of the bundle. So this is my skeleton argument. And paragraph 24, you'll see heading common grounds of appeal. And you'll see that under that heading, I have in one sentence sort of succinctly identified the ground that is being pursued, which is that it is arguable that the Secretary of State's approach to the exercise of discretion was flawed, and the reasons were defective and inadequate in each case. So if you are persuaded by the submissions that I've made, and if you decide to allow the appeal and grant permission and remit the case, I simply seek permission on this ground. And this is a ground that I do say appears not entirely clearly, but in substance in various pleadings.
So would you seek permission to amend the grounds in each case to cover that? The ground as so formulated, because one thing that's emerged from the discussion of the grounds is that they're somewhat diffuse and not as clear. I think you've conceded in at least one case they could be clearer.
Yes. So this is really the ground, but I do say that you, of course, it's now almost 4:30, and this isn't a case where one would, in my submission, where the broader legal argument here, and this isn't a case where perhaps it would be appropriate to sort of forensically analyze the pleadings to see precisely where the point is made. But I do submit that in substance, one way or another, this is really the underlying point that was being made, and this isn't a new point, and in fairness, of course, the point about pleadings only arose from the questions that my lords and my lady you asked. My learned friend very properly hasn't taken up sort of pleadings point, and no one is suggesting that you should sort of knock out the appeal on the basis that a point was not sort of properly pleaded. I'm very grateful for your patience. These are my submissions in reply.
Very good. Thank you both very much, and those behind you. We will obviously be reserving our decision, and I'm sure everybody in court is very familiar with the procedure, so you will get a draft for you to correct typographical errors, wrong dates, and things like that, not to re-argue the case. And the draft obviously will be under embargo, and I'm sure everybody appreciates the importance of observing the embargo. In addition, We hope that at that stage you will be able to agree a consequential order. If for some reason you can't agree a consequential order, then please brief written submission. Thank you.
Court rise.